Welcome. My name is Steve Sanders. I teach here in the law school. This event is part of a series of programs at IU Bloomington this academic year centered around the theme of dignity, equality, and social justice. It's made possible by the REMAC seminar named for the late IU faculty member Henry REMAC. And the REMAC seminar is an initiative of the IU Bloomington Institute for Advanced Study. Several of my colleagues who are part of the seminar this year are here. I see Luis Fuentes-Royer back there, Colin Johnson, Brian Powell. Is there anyone else from the seminar? Okay. The program today is also made possible by the Maurer School of Law and by the Center for Constitutional Democracy, which is directed by my colleagues David and Susan Williams, who are here with us today. The concept of dignity has deep roots in the world's major religions as well as philosophy. Human dignity became a central feature of human rights discourse after World War II, and express references to dignity appear in the constitutions of many nations and in the Charter of the United Nations. The United States Supreme Court's decisions on same-sex marriage, United States versus Windsor and Obergefell versus Hodges, with their striking and multiple references to dignity as a principle that's tied closely to equality and to the right not to be gratuitously injured by one's government, these decisions seem to place the idea of dignity at the center of contemporary constitutional discourse in this country. Our guest today is an internationally renowned constitutional jurist and scholar whose own work, including his book last year, Human Dignity, the Constitutional Value, and the Constitutional Right, his own work, both as a jurist and as a scholar, has advanced the idea of human dignity protected by law. Aharon Barak received his doctorate in law from Hebrew University in Jerusalem and later served for many years as a faculty member and dean at that institution. From 1975 to 1978, he served as Attorney General of the State of Israel, and in 1978 he was appointed a justice of the Supreme Court of Israel, and he served as president of that court from 1995 until his retirement in 2006. Since 2007, he's been a faculty member at the Interdisciplinary Center in Herzliya, Israel. His publications and honors are too numerous to list, but I'll mention just one accolade. Our own Supreme Court Justice, Elena Kagan, when she was Dean of Harvard Law School, called Justice Barak the judge or justice in my lifetime who best represents and has best advanced the values of democracy and human rights, of the rule of law, and of justice. Justice Barak joins us today from New York, where he's presently a visiting professor at the NYU School of Law. Justice Barak, I'm going to ask if my colleague can just use the camera briefly to show you your audience here today. We're joined by students and faculty from the Indiana University Maurer School of Law, as well as from the broader campus of Indiana University. So thank you for being here.
Thank you very much for having me.
Okay. If the average person hears the term human dignity, it probably seems to them like a concept more at home in philosophy or theology than law. In your book, you trace the history of the social value of human dignity through intellectual movements and world religions, but you ultimately say that although constitutional lawyers should learn from and appreciate the approaches of theologians and philosophers, giving meaning to dignity as a constitutional value must be its own enterprise. So I want to start by asking, does this mean that dignity will always mean something different in each country, in each constitutional tradition, in each era? Or are there transcendent principles that unite the meaning of dignity in all of these constitutions that can be traced back to some common heritage in philosophy or in religion?
Well, I think both answers are right. The moment dignity appears in a constitutional context, whether as a value or as a right, it becomes a legal concept, and we should approach it in the same way that we approach other legal concepts. So we are using the regular tools, the regular kit we have as lawyers, namely constitutional interpretation. But constitutional interpretation is not limited just to the text. I don't know any constitutional theory of interpretation which says the text and only the text, nothing but the text. There's always something else that is taken into account, whether you are an originalist, so the original understanding, whether you are an intentionalist, the intent of the founding fathers, or you are a living tree or a living constitution, a purposive interpretation. Whatever it is, you must take something which is external to the text. And the moment you take something which is external to the text, you move to areas which brings you back to history, and which brings you back to the intellectual history of human dignity in our case, but in other cases. Holmes said, 1 page of history is more important than 100 pages of logic. So that's it, it's Holmes. And so ultimately, though every legal system has its own architecture, and every legal system thus will give its own meaning of the text, and one meaning may differ from the other, ultimately, the core of dignity and the core understanding of what this dignity is all about will in many cases be similar in different legal systems.
As an important value of secular law, human dignity really sort of got going after the Second World War. Today, dignity is expressly mentioned in, I believe, 32 of 45 European constitutions, as well as most of the constitutions of Latin America, the African states, the Asian states, the state of Israel. How and why did human dignity so rapidly find a place in just the last 60 or 70 years at the center of international agreements and really at the center of human rights and constitutional discourse? This is a relatively new development. How do you explain its rise after World War II?
Well, again, history. World War II was an event in which human dignity was violated on the most fundamental levels. Whatever you understand in dignity is all about, it was violated by the Nazis and the collaborators in World War II. And so one of the lessons of World War II was we have to protect dignity as a constitutional idea. And it starts in the Universal Declaration of Human Rights, in which, in the Universal Declaration, human dignity is playing a very major role. And I think from World War II, from the atrocities of the Nazis, immediately when the German Grundgesetz was constituted, the first article, it's a long constitution, but the first article, this first subsection of the first article says dignity is an absolute right. Unantastbar is untouchable. You can't amend, it's unamendable, as said later. And from there, it spread all over.
Okay. In your book, you first draw a distinction between human dignity as a constitutional value as opposed to human dignity as a constitutional right. I want to get into the details of that distinction further, but first, can you just explain that basic difference, how dignity is found as a value in some constitutions, but really as a right in others? What's the difference between those two?
Well, if you have a constitutional right, it means there is a constitutional duty, and it means that if this duty was violated, if the right was violated, if the duty was not fulfilled, you have constitutional remedies. So a court may declare, for example, a statute as unconstitutional if the right of dignity was limited in an unconstitutional way. So that's a right. If it's only a value, and if this value is violated, nothing happens because it's not a right. But the importance of the value is that you use the value in order to construe, in order to interpret the right. So if an American court, for example, will construe the Eighth Amendment of cruel and unusual punishment to say, cruel and unusual punishment is a punishment which affects the dignity of the human being, for example, then if there is a violation of this value, which helps to construe the right, you will reach also to judicial review as in the situation of the right. But if the value is just a value and it's not connected to a right, you cannot connect it with a given right. So it is inspirational, and it gives you a clue to construe other rights. And this is, in fact, what happens in the United States.
Can you say, and I want to explore specifically the role that dignity has played in American jurisprudence, but from your work in other constitutions, can you provide a couple of other examples of how dignity as a constitutional value, not as a right, but simply a value, has affected the interpretation of the Constitution or given meaning to other parts of a Constitution? You've said that human dignity unites all human rights into one whole, and so that indicates it's a very powerful concept in just interpreting more specific constitutional provisions.
That's right. So in the United States, in my book, I think I mentioned that there are more than 800 cases of the American Supreme Court in which human dignity is mentioned, and not just after World War II, even before World War II. And it's always mentioned not as a right, it is mentioned as a value. It's mentioned as a value together with other values that help the judges to construe the different provisions of the American Constitution, mainly the Bill of Rights, its Eighth Amendment, Fourth Amendment, Second Amendment, First Amendment, all the amendments. If you want to give them a meaning, you take into account, inter alia, the value of dignity. Take, for example, a good example is Canada. Canada has a constitution, of course, and it has a Bill of Rights. It's called the Charter of Rights. Now, in this Charter of Rights, dignity does not appear as a right. The word dignity, as in American Constitution, is not mentioned at all. However, the Supreme Court of Canada had no difficulty in deciding, in a line of cases, that the concept of equality should be construed according to the value of dignity. So equality or discrimination is a situation in which you distinguished between individuals in a way that affects their dignity. So this was a judgment, a famous judgment rendered by the Canadian Supreme Court. Later they overruled it partially, etc. But here we have another example. And there are many other legal systems. In Spain, for example, the Constitution of Spain has a specific article about dignity, but it's clearly that from reading the text within the context that it's just a value. So it affects the way you consider other rights. But in order to give it a bite, you need a right. No right, no bite.
You said at the beginning that you thought that the concept of dignity had usefulness or could be brought to interpretation through a variety of interpretive lenses, whether one's a textualist or an originalist or what's sometimes called a living constitutionalist or a believer in a common law constitution. Could you say more about that? I guess from reading your book, it seems that you draw a distinction between the intent of a constitution's framers or its original public meaning, and what you call the fundamental purpose underlying the Constitution at the time of interpretation. Is this another way of saying that to really find a value of dignity, if it's not expressly protected in the text, that the Constitution must be understood as a living document? Or could even a textualist or a person who believes in originalism and original meaning find a value of dignity in a constitution as old as the one in the United States, for example?
Yeah, I think so. I think that whatever your theory of interpretation is, and there are many theories of interpretation, but let's take these three ones. Whatever your theory is, you can give effect to dignity. It will be another kind of effect. The consequences may be different, but the idea of giving effect to dignity will be the same. So take, for example, the originalism or public originalism, what the late Justice Scalia was advocating. So you construe the a text according to the public meaning at the time of enacting this text. So when you are coming with, let's say, the interpretation of the Eighth Amendment in this respect, Justice Scalia will ask itself, what was the public understanding of Americans in 1793 when they constituted the Eighth Amendment? Have they, when they said cruel and unusual, was dignity in their mind? This is a question. And if history will tell him that was, he will give effect to dignity. He is an originalist, but he is a faithful originalist. And if dignity was part of the public meaning, he will give effect to it. If Blackstone was thinking about dignity, also Scalia will think about dignity. So that's an easy situation. If you are an intentionalist. So you ask yourself, what is the intent of the founding fathers? Madison, Hamilton, and other founding fathers. Okay, so you ask the same question. When the Eighth Amendment was enacted, was there intent to give effect to the idea of dignity, to the value of dignity? Either yes or no, it depends on the answer. It may be a situation in which the public understanding was dignity, yes, but the intention of those who made it, no, and vice versa. When you are coming to the third theory, which is my theory, and this is the theory, let's say, of Justice Brennan in the United States, Justice Kirby in Australia, and other judges all over the world, that the Constitution should be given such a meaning that expresses the values of a given legal system at time of interpretation. So it's the living constitution, or the living tree, as the Canadians call it, or the purposive interpretation, as I call it. And then you ask yourself, is human dignity part of the values of a given society at a given time? Now, you see, so all three systems may give effect to dignity. They may not give effect to dignity. You may have a situation in which, when the text was enacted, the original understanding was dignity is there. Now the understanding is different. Totally. Dignity doesn't play a role. May happen. So for me, if there is such a basic change in the understanding of the legal system, and I'm talking about a basic change, not of the fleeting hours. It's history, not hysteria. That's my theory. But then the different legal system will give different, will have different approaches to the idea of dignity.
Staying with dignity as a value for another moment before we talk about it as a specific right, I think a common theme in, for example, Eighth Amendment jurisprudence is this idea of the moral progress of an evolving society. So if one is a purposivist or a living constitutionalist or a common law constitutionalist, do you believe that human dignity means something different today than it did perhaps to the authors of the Constitution or the authors of the 14th Amendment or even the authors of constitutions in the early part of the 20th century? Is human dignity a fixed concept, or does it evolve in its meaning, in the contexts in which it applies, in the kinds of government behavior it's thought to restrain?
Well, we're coming back to your first question. So I think that it is an evolving principle. It may mean one thing in 1793. It may mean another thing in 2016. But the changes here are less drastic than the changes in traffic. Because this is such a basic concept, and basic concepts are not changed very frequently, very quickly. But if you ask the theoretical question, should we ask what was then the understanding of dignity, or should we ask what is our understanding now? My answer, under purposive interpretation, it's now. Under originalism and intentionalism, it's then. But the difference between those two may not be very, very substantial.
If, for example, under the Eighth Amendment, a particular kind of punishment was thought to be perfectly acceptable in the late 18th century, but we would find it repugnant or unacceptable today, does that mean that our notion of human dignity has changed, or simply that sort of human dignity is a fixed principle and we've just adjusted our notions of the kinds of things that offend human dignity?
Well, so here it will depend how much you go into the details of it. I think that you may assume that in 1793, death penalty, for example, was not in violation of human dignity because it was usual. So it's not unusual. So if it was usual, then it's fine, or at least part of it being fine. Things have changed. So we may think that it is unusual. In both situations, we may think that it is cruel. But is it usual or unusual? Those things have changed. So I think all the basics ideas that you are talking, I mean, we are now discussing dignity. Let me ask you the same question about liberty. Was the idea of what is liberty in 1793 and liberty now, is it the same liberty we are talking about, or is it a different kind of liberty? And I think the answer is there is much in common, but there are also differences. The life of law is not stability, and the life of law is not change. The life of law is change, is having stability plus change.
And as you said, Holmes said it's also experience. It's our experience as
and experience. Exactly. What happened, our experience as it happened, as World War II, we learned the lessons of World War II.
In many nations, human dignity is not only a value, but appears in the text of the Constitution as a right. And just to give a few examples, Article 1 of the German Basic Law declares human dignity shall be inviolable. To respect and protect it shall be the duty of all state authority. Article 10 of the South African Constitution says everyone has inherent dignity and the right to have their dignity respected and protected. The word dignity appears twice in the Basic Law of Israel. Yet, even where it's an express right, dignity still probably strikes many people, even lawyers, as a malleable concept, an amorphous concept. Courts protect dignity in specific cases involving concrete facts and concrete legal decisions. And so, drawing perhaps on your own experience as a justice on a constitutional court, could you describe a couple of specific examples of how this constitutional right of dignity was translated and applied to a specific legal question?
You see, when I talk about dignity with philosophers and theologians, they tell me how dignity is complicated and how dignity is an open idea, and you can't apply it in daily life. And I tell them, well, that's your views as theologians. I understand it. And that's your views as philosophers. I understand it. I am neither a theologian nor a philosopher. I am a lawyer. I am a judge. I have a question before me. I have to solve it. And please tell me, I tell them, can you work with the idea of liberty? Oh, liberty for them is a complicated idea. Can you work with equality? Oh, equality is a very complicated idea, and who knows? Okay, but that's my job. I cannot say it's a complicated idea and I go to sleep, right? I have to decide a case, and the case says dignity, and I have to give meaning to what dignity means. And the tools I'm using to say what dignity means are the same tools I'm using to say what liberty means, what equality means, and what privacy means, and what property means, etc. And the tools are the regular tools, interpretation, etc. So you ask me in a legal system, what in reality, what do you say? So, for example, Germany. In Germany, the dignity is an absolute right, which means the moment you affect dignity, you are dead, quote unquote. It means a statute that affects dignity is unconstitutional per se, without going into any level of scrutiny. Even if there's a pressing state interest, doesn't matter. The moment you affect dignity, you are dead. The statute is unconstitutional. Clearly, if that's the architecture of the basic law, the German basic law, dignity is given by the courts a very narrow understanding, because you cannot live with the right of dignity as an absolute that has a very wide meaning. So for them, dignity basically means the taboo cases in which it is clear that for them that the state just can't do it. So, for example, minimum economic existence is for the Germans a taboo, and therefore, if someone has no means, a homeless person under the German constitution has a constitutional right to dignity, and the state has to do something that the homeless will have a place to sleep, that the homeless will have food to eat, etc. So, for me, it's an easy case, in fact.
In that case, it becomes an affirmative obligation, a positive right, not simply a negative right.
Of course. It's a positive right. The legislature has to do it. If the legislature doesn't do it, you will have a case in the Constitutional Court of Germany, and the Constitutional Court of Germany will tell the legislature within a year you must enact a statute that will provide A, B, C, D. And the German legislature will enact a statute within 1 year for A, B, and C. And that's the end of the story. Easy case. When you take the situation, for example, in South Africa, they have dignity. What does dignity mean? Well, the Constitutional Court of South Africa said, look, we have a whole list of rights. It's the most beautiful constitution on earth. If anyone is interested in the beauty in law, in the architecture, go to the South African constitution and we'll see how nicely it is structured, etc. So they have a whole list of rights, I think 30 or more. One of them is dignity. So they said, look, if we have a specific right, go there. Don't go to dignity. But if there is no other specific right, visit dignity and we will see what happens there. So, for example, right to education, they don't need dignity. Because right to education, they have a right for education. They have a right, a positive right to education. The state must provide education. Constitutional right, remedies, constitutional remedies, education, health, and other. There's a whole list of positive social and economic rights. But suddenly they realized, and I don't know what the reason is, there is no specific constitutional right for a reputation, to protect one's reputation. There's no right to reputation. So the Constitutional Court of South Africa had no problem in saying, well, reputation, that's protected by dignity. Easy. It's not an absolute right. It's a relative right. So you can apply to America will apply their levels of scrutiny. They will have to decide if it's strict scrutiny, medium scrutiny, minimal scrutiny. In Israel, we will apply to that, or in South Africa, they apply to it proportionality because they have a provision about proportionality. Another example is they had a case of family unification. So a South African married a non-South African. The non-South African wanted to enter into South Africa. South Africa said no. And the question was, does the South African have a constitutional right that his spouse will come in? They looked around, no article. Dignity. So
you served for many years in a very distinguished career on your own country's Supreme Court. Can you talk about
28 years.
28 years. Can you talk about a case that is particularly memorable to you, where you drew on the textual guarantee of dignity in the Constitution of Israel to protect a specific right? So give us an example of how you took it and applied it to the facts and the law in front of you, as you say.
One right. I think I wrote more than 100 judgments on dignity. I can give you 100 examples. Because the reason why I can give you so many examples is we have the right to dignity, but we have very few other rights. So when South Africa sends its petitioners, go to the other rights, found the solution there, I can send them to the other rights because I don't have them. I have a very limited, partial Bill of Rights because of historical reasons. Our Bill of Rights is still a work in process, so we haven't finished it. All right, so you want examples for dignity. Here, equality. So we don't have a right of equality, we don't have a 14th Amendment as it stands, or a substantial due process as it stands on its own feet. We don't have it for historical reasons. But the court said, look, so the court said, look, I as a judge, or I said, because I wrote this judgment, I as a judge cannot decide that we don't have equality, we have equality. That's not in the cards. I'm a faithful interpreter of the constitutional text, whatever my theory of interpretation is. But I can say, and I said, that to the extent that discrimination affects one's dignity, then the right to dignity is triggered, and we move into the proportionality stage. In America, you will be moving into the levels of scrutiny. So I had cases in which the question came up, was the dignity in terms of equality violated, or wasn't it, or was it not violated? And I have a whole line of cases dealing just with equality. But equality is only one of those circumstances. There are others. So, for example, we decided that the right to equality, dignity, includes the right to a minimum amount of existence. So it meant the right to education, it meant a right to health, it meant a right to housing, etc. I mean, take a demonstration of the poor in the main square of the city. We want housing. And they have their tents there. And the municipality comes and says, tents out, you are trespassers. Under the law of torts, they are trespassers. That they don't have any claim under the law of torts. In my theory, of course, I would order them go out. But before I order them go out, I would ask the municipality, okay, here is my order, they go out. Where to? Where to? When God said to Abraham, go from Iraq, go, he told them where to go. So you tell them, go. Where should they go? So I wouldn't give the order out before the municipality would come and say, okay, here is another spot where I will build some tents or very minimal housing. There will be water, there will be sanitation there. After all those requirements are there, I will give the order. So yes, I've done it in many cases. But it's not only of inequality, it's not only a minimum existence. It's, for example, the right to family life. We had a case in which, because of terrorist activities, spouses who came to Israel under family reunification program, those spouses were involved in terrorism. So there was a statute that says no family reunification for a year. And we had to decide if the statute is unconstitutional. So the first question was, what right is affected here? And we are talking about the right of the Israeli spouse, not of the foreign spouse, which is an interesting question in itself. So in terms of the right of the Israeli spouse, we looked around in our Bill of Rights, look around the new Bill of Rights, you will not find the right to family reunification. But I said, family reunification, if you don't allow the spouses to live together, they and their children, you affect their dignity. Dignity is involved. And I have a whole line of cases.
Won't judicial interpretations of dignity inevitably involve judgments that are inseparable from political values and judgments? And so, for example, a political liberal may believe that constitutional dignity requires the state to recognize same-sex marriage or other types of marriages that are not currently recognized, but not any right for an unborn fetus. A political conservative may feel exactly the opposite. The dignity protects potential human life, but has no relationship to sexuality or relationships. And so what is your response to the objection, I'm sure you've heard it, that where constitutional dignity is a sort of framework right, as you say, judicial decisions about what you call daughter rights, the rights that flow from dignity, will always involve contested and subjective judgments about values and politics, about What deserves dignity and what does not deserve dignity?
Well, to answer properly this question, I wrote another book, The Role of a Judge in a Democracy. So some other time I can, but my quick answer will be, I will ask you now, when you have the word liberty, which you have in your constitution, does liberty include privacy? This was the question. And one will say liberty includes privacy. The other one will say liberty does not include privacy. In other words, all this question you ask me about dignity will apply to liberty. Now, do you have an answer to liberty? The same answer you give to liberty, I will give to privacy. You see? I will give to dignity. In other words, I do agree that different judges may have different views about what is the understanding of their legal community about dignity. Of course, if a judge is an originalist, he will ask himself, dignity then. Two originalists may disagree about dignity then. Or two intentionalists may disagree about intention. What was the intent then? When Hamilton said dignity and Madison said dignity, were they thinking about the same thing? Or do we care about what they were thinking when we are intentionalists? Do we care about the question, how they have construed dignity? Or do we care only on the question, have they thought about dignity? But if they have thought about dignity, the construction of dignity, we will do it ourselves. And the same legal questions that you encounter in the regular, tough constitutional law. Constitutional law is a complicated matter. But the same questions that you will have then, you will have also here. So yes, I can understand that two judges that agree with me about the living constitution, let's call it in American terms, or purposive interpretation. What is the purpose? Very different. One will say, look, dignity does not include the right to education. Or if it includes the right to education, it means only to give the minimum tools for education, but it doesn't include education, free education, for example. Another one will say, no, it includes. But the difference between them will not be great, as it seems to be, for the following reason. Even if you have a judge, and I'm one of those, who would give to dignity a very wide interpretation, almost everything can, in one way or the other, affect dignity. For me, dignity is the ability of the human being to write his life story, in a nutshell, so to speak. So it's a very large, but this doesn't mean that a statute that limits dignity or a statute that does not provide dignity is unconstitutional, because my constitutional thinking is working not in one level, do I or don't I have a right, but it also moves to the second level. Is there a justification for limiting the right? Is there a justification for not fulfilling the right? And in many cases, there are justifications for not fulfilling the rights, and there is very good reasons for limiting the right. And so even if you have two liberals or two non-liberals, they will come ultimately in many cases at the end result to the same result. One will say there is no right. The other one will say there is a right, but the limitation of the right is constitutional. Take, for example, the question of abortion, which you mentioned. One way to deal with it is to talk about the dignitary right of the mother. The mother, the woman who is pregnant, her dignity means her ability to write her life story, and therefore she has a right to abortion. Let's say that you say so. Then you are a pro-life. You said, no. Okay. But here, if you are pro-life, you will say no dignity. But there is other way to deal with it. Even if you are not a pro-life, you may have a problem answering the following question. Is there a state interest to protect the life of the fetus? Even if you think that the fetus has no right in itself, because he was not born yet, the state may still have an interest that fetus will be born as a state interest. And I, for example, that I'm in favor of a woman, of a constitutional right of a woman to have an abortion, as was decided in Roe v. Wade, I do also recognize that there is a state interest in not aborting. And those two values are in, or the right and the state interest are in conflict, and they are relevant in the second stage, in the stage of justification. And I can reach a similar result that others would reach by using other techniques.
Turning to the United States, specifically, the term dignity does not appear in our Constitution, although, as we've discussed, it's often said to be a value that underlies the Fourth Amendment right against unreasonable searches and seizures, or the Eighth Amendment right against cruel and unusual punishment. In your book, you identify two justices in particular, the late William Brennan and the current Justice Anthony Kennedy, as having made particular contributions to dignity as a constitutional value. I want to ask you specifically about the gay rights and same-sex marriage cases, but first, how would you describe briefly the meaning that dignity has come to have as a constitutional value in the United States right now? Has Justice Kennedy's work in various areas of the law significantly advanced that project?
It's an interesting question. I don't think I have an answer to that question because, as I mentioned earlier, in more than 800 cases, dignity was used. After World War II in the 40s, 44, 45, 46, dignity was used. All the cases with the Japanese, the war crime cases, dignity was used very strongly. And now it is used by Justice Brennan, as you mentioned, and now it is used by Justice Kennedy and by other judges. But I cannot extract from it a theory about what the value of dignity is all about. I just don't know, because it was mixed with other considerations. And to give a reliable answer, what dignity means under the American legal system, I don't know.
If you, I assume you've had a chance to read and consider the Supreme Court's gay marriage opinions. Your book was published before the Supreme Court's decision in 2015, authored by Justice Kennedy, striking down laws against same-sex marriage, and many commentators were struck by the number of times the word dignity appeared in the Obergefell opinion. The word was also used 2 years before in striking down the Federal Defense of Marriage Act, and in 2003 in a decision invalidating sodomy laws, Lawrence versus Texas. Professor Lawrence Tribe at Harvard has praised Justice Kennedy for combining the 14th Amendment principles of liberty and equal protection into what he calls the double helix of a right to equal dignity. This is, I guess, similar to the last question I asked you, but do you agree with that assessment, or is it really premature? Have these gay rights cases, gay and lesbian rights cases, opened the way, do you think, or charted a doctrinal path for dignity to play a larger role in American constitutional law?
It depends very much about the judges. Technically, there's no problem in writing a judgment that dignity is a constitutional right in the United States and not just a value. And the road is very simple. You have decided that privacy is part of liberty. You have the same way that privacy is part of liberty, and even more, dignity is part of liberty.
So you think in the American context, due process clause, liberty specifically, is sort of the best home for extracting a right to dignity?
Absolutely. And it can be done. If you take Griswold versus Connecticut, if you talk about the penumbras that Justice Douglas was talking, of course, the dignity is more in the penumbras of all the amendments than the privacy. And he was ready and willing to do it with privacy. So why not do it with liberty? I myself am unhappy with this kind of reasoning. I think the privacy comes from liberty and not from penumbras. But the idea of liberty is such, as developed by the American Supreme Court, that it can house, and it houses privacy, it can house also dignity. Why not? It just has to be a decision. Now, rightly, when one reads all the judgments of both the two justices you mentioned, Brennan and Kennedy, they have not made this step. They have not decided that dignity is a constitutional right. It's only a constitutional value. they are judges in America. I'm not the judge in America, and they understand the American situation much better than I do. But in Israel, I would have no problem to exert a dignity out of liberty if I would have a liberty provision. In fact, I have a liberty provision, but I don't need it because I have a dignity provision. If I would not have a liberty provision, I could extract the liberty provision from dignity. You see, that's easier.
Justice Barak, in the time we have remaining, I want to see if members of the audience have any questions. I'll ask, and then I'll repeat them so you can hear them.
Pleasure.
Questions? Yes.
I'm wondering, from the description, it sounds as though when there is a specific right to dignity in a given constitution, its function is primarily a gap-filling function. So if we had a more specific right to whatever is at issue in the case, we would go to that. But if we don't, then we can fall back on dignity. What I'm wondering is there anything that a right to dignity would do that is distinct from what could be achieved under any other substantive right? In other words, what would count as a violation of dignity but wouldn't count as a violation of liberty, freedom of speech, privacy, family, relationships, and so on?
Where these are textually guaranteed.
Exactly.
Okay.
Assume you had a completely thorough constitution that included all those other rights. Would you still want a right to dignity?
Okay. Justice Barak, did you hear
That, or would you like me to repeat
Yeah, I
it?
heard it. No, I heard it. It's fine. The situation that was described by the question, in fact, exists in Germany, because Germany has a right to dignity, but it has another right, that every person has a constitutional right to develop his personality. Point. Developing of personality. And the question in Germany really comes in, well, if you have a constitutional right of developing one's personality, what remains for dignity? And the truth of the matter is that for dignity, there is a very limited place to play in the German constitutional law. But don't forget, in Germany, dignity is an absolute. You touch it, you are dead. If you touch under the right to develop of one personality, they decided, for example, that if a statute forbids me from feeding pagans on the square of a city, it limits my development of personality. My constitutional right was limited. Very nice. But then when we go to justification, it is a justified limitation. So the question therefore comes in, the question I was asked, what is the role of dignity if in a legal system that has all the other rights and it has also dignity, and dignity is not an absolute right, but is a relative right? That's the real question. And my answer to this real question is, I don't agree with the South African Constitution that if you have a specific right, you don't go to dignity. Dignity should apply in every case. And let me give you the example to show my point. In South Africa, they have all these social rights, but every one of the social rights has an internal limitation that says subject to the economic situation of the country. So this subject to makes the right narrower. So now comes a situation of a social and economic right in which the case is, but the answer is your right was not limited because the subject to the financial situations is operative. The famous case is the case in which someone who needed a machine for his kidney, and the hospital had a very few machines, and he was the last in the line. So he brought an action against South Africa. Let me in. And the court said, the court dismissed his case. In fact, the case was dismissed on the day he died. The court dismissed the case because they said, look, there is a right of health, but the right is subject to the limitations of our financial possibility. And there's no financial possibility. I think that under those circumstances, though there is a specific right to health, one should go into dignity. His dignity was affected. His life story was affected. His autonomy of will was affected. His ability to exercise to develop his personality was affected.
The state's economic constraints.
And now the state economic constraint is not a part of the definition of the right. So we will move to justification. In the justification, we will ask the state, okay, you don't have money for that, but why do you have money for something else? So in the justification, this question may come up. And the net result may also be here, no money, no rights. But the answer may be, rights cost money. So here, the battle will be there on the justification, and not as in South Africa, that the battle is on the definition of the right. So to answer the question I was asked, dignity plays a role in all situations, in a very wide situation. And we should move always to justification. So my theory is basically that the main work that is done when you have constitutional rights that are and there are statutes that affect those rights, the main work is done not on the definition of the right, the situation you have in the United States, but in the justification for it, for the limitation.
Are there other questions? Colin.
I'm not a law professor, and I don't play one on TV, so I'm going to ask a question that may not make sense in legal terms. Is dignity a right that can only be talked about in kind of individual terms? I'm thinking, for example, about feminists theorizing having to do with pornography, for example, and the way in which pornography was sort of covered by freedom of expression, and people sort of defended it very heartily under the terms of protecting freedom of expression. But there was a line of argument that basically said modes of representation of women as sort of sexualized, humiliated, brutalized, beaten are fundamentally sort of problematic because of the fact that they both produce social realities and also affect people's dignity in a real, like deprive women of dignity, which is basically crucial to speech, essentially. I mean, there was a certain McKinnon famously. But does dignity, is it an individual thing or is it a social thing? Like, does the manner in which one is represented, for example, have implications in terms of one's right to claim violations of one's dignity?
Did you hear that okay?
Yeah, I heard it. Well, I think it's an important question. When you are coming to the resolutions I am already in, this question may come up. To write one's own, if dignity means to write one's own story, is it your story or is it the way your story is understood by the others? And my answer is as it is understood by me. Because dignity is a right of every individual as an individual. It is not a collective right. It is an individual right. Dignity of the human being as a human being. About pornography, my theory is that free speech includes pornography, even hardcore pornography. On the other hand, we are moving into the justification area. And of course, there is a very strong justification to prohibit hardcore pornography or some types of pornography and not a justification to limit other parts of pornography. And the battle should be made there.
Other questions? Yes, in the back. Speak up.
I haven't read your book, and I apologize for that. You may have answered this in that work. The way I'm understanding your conception of dignity here is it's a fluid thing that is going to be annexed to particulars about a particular society, even though that it doesn't change that much over time because it is a basic sort of fundamental tenet. If that's the case, does it offer us really any protections against ourselves, or is it just a vehicle for our moral interpretations to come into our law? More specifically, dignity is something that you don't, if you view a group or an individual as an other, you don't necessarily extend dignity to them. So let's imagine that the pre-World War II government in Germany had an idea of dignity, but decided that it didn't extend to the persecuted people and the actions that they carried out. Because dignity is annexed to our understanding of who deserves dignity and what it means in that particular society at a time, does it offer us any real protections?
assumption in Germany, it will not offer any protection because their understanding, and in your example, is to have this sign that isolates you from the other people, doesn't affect one's dignity. But that's not my understanding of the idea of dignity. I don't think that this is the common understanding of the idea of dignity. And even people who have a very narrow understanding of dignity, or a narrower understanding of dignity than I have. For example, there's a whole line of thinking that dignity means until humiliation. Your dignity is affected if you are humiliated, but not outside it. I think it's too narrow. But even if you would have this kind of narrow definition of dignity, which I think almost everyone has, that dignity includes humiliation, and the battle, quote unquote, is outside that, then the example that I was given is a humiliation situation. Look, you go on the street and everyone said, aha, that's the Jewish guy, we can beat him. But on the law, not the example you gave, but let's say the theory you gave, I think that it has a lot of bite, if that's the question. It has a lot of bite because I think if you give to it, as I do, and as many judges in the world do, I mean, I'm not the only one who does so, that gives a very wide interpretation of dignity, which means we have a very wide interpretation of our right as an individual in this society. Don't forget, dignity is not the right of Robinson Crusoe. Robinson Crusoe doesn't need any rights at all. But if the moment another guy comes there, more than two, you need dignity. So if you have such a wide definition of dignity, then you are moved to the question of justification. Therefore, I wrote another book, which is called Just Proportionality, which is the way to understand justification. And there is a whole theory about justification. And when you have not only so you need to, if you have a theory about dignity, you need a theory about justification, clearly. But I have both theories. I have a theory about dignity, and I have a theory about justification. And in some key situations, in many cases, my dignity is affected, though there is a justification for it. I mean, every prisoner, his dignity is affected, his liberty is affected. Would you say, therefore, liberty doesn't mean anything? No, it means a lot. But there are kinds of cases in which the liberty should be affected and is justified. And there are other cases in which it should not be justified. And we need a theory of justification. It's not something that is left to the wild discretion of judges. And there is such a theory. All the countries that are using dignity have also a theory about proportionality, which means it can be limited if the limitation is proportional. What it means in proportionality? It has to be for a proper purpose. Let's see the purpose. There must be a rational connection between means and ends. There must be the necessity. There is no less intrusive alternative. And ultimately, what you don't have, the balancing. The ad hoc balancing, not principled balancing between strict scrutiny and medium scrutiny, but ad hoc balancing in every given case. And it works. It works very well. You don't have it. I don't. It's not my purpose or my aim to preach that you will have proportionality. Justice Steve Breyer thinks that it's a good idea. All right. I'm happy that we share the same idea. But proportionality. Sorry.
The topic of the future.
Supreme Court is of lively interest right now after Tuesday. But that's a topic for another time, probably.
The future of the Supreme Court is always interesting. Before the elections, after the elections, in the elections. But that's another matter.
Justice Barak, would you like to?
The very nice person behind you there. She's been visible, so I thought you might like to introduce her briefly.
Well, the nice person. The nice person behind me is my wife. We are married almost 60 years. We met each other when we were in ninth grade at school. And since then we are together, hopefully, as we say, metaphorically, eternally, which means